Welcome everyone to this episode of On the Ground. And today we're joined with Karen Chipita, an expert in foreign legal affairs at Wanjing GH Law Firm. Wanjing GH Law Firm is headquartered here in Guangzhou with expertise in handling Chinese employment disputes on behalf of foreign companies. Good morning, Karen.
Good morning, Ben.
So why don't you give a better introduction of yourself?
Okay. First of all, thank you for having me here. It's a great pleasure. I'm originally from Zambia. I studied law 4 years in Zambia and later completed my bar qualification, which was a year. I obtained my practicing license in Zambia. However, I moved to China. So while I was studying in Zambia, I was working as well, gaining work experience and practical experience. Then I moved to China and I've been here for close to 2 years. I've been working for Wanjing for nearly 2 years as well. And basically we have a foreign legal affairs department that is mainly designated to assisting foreign companies, foreign invested enterprises, and foreign individuals as well with their legal requirements. We focus on commercial disputes, labor law. Do you need me to go on and on and on about what we do?
all sorts. No, that's really interesting. Actually, just quickly, what brought you to China?
What brought me to China?
Yeah.
That's a good question. My mom was working as a diplomat here in the
really?
Zambian consulate. Wow. Yes, and that's how I came. I initially came to, just visit her. Then basically I ended up making a few applications in law firms just to see if I could stand a chance.
Yeah.
And that's how I ended up finding myself here at Wanjing.
No, well, that's brilliant. I mean, I think more companies need these foreign legal experts, people with experience overseas, but also here in China to help navigate, all the different challenges. And today, I mean, thank you for having us. We're in the lovely offices of Wanjing GH. And today we're going to talk about the top 5 legal disputes that foreign companies have with Chinese employees in China. And sort of specifically foreign companies and Chinese employees, because as we discussed, potentially a Chinese company would have different types of disputes with Chinese employees.
Yeah.
And also potentially foreign companies and with foreign employees. So today we're going to talk mainly about foreign companies, foreign invested companies with Chinese employees. There is no question that employees in China work hard, often staying late without complaints, and employers assuming that everything is fine. But that is where things get tricky. Just because an employee doesn't say anything at the time doesn't mean that they've given up their rights. In China, an employee's legal protections are enshrined in law, and those rights don't just disappear because they weren't enforced immediately. So when do these issues surface? When do these disputes come up to haunt you? Often it's at the point of termination or when another dispute arises. The employee, feeling wronged, looks back at all the things that weren't addressed earlier. Unpaid overtime, social insurance missed, unfair contract terms, and suddenly the employer is facing a legal claim that they never saw coming. This is why it's crucial for foreign companies to get HR compliance right from day one. Even if the relationship seems good and the employee and the employees seem happy, assuming they'll let things slide, this is a risky strategy. When disputes arise, the law is almost always on the employee's side, and that can lead to more disputes and unexpected severance payouts. So, the smooth employer-employee relationship isn't just about the day-to-day harmony. It's about staying compliant, maintaining structure, even when things seem fine. Because when things go wrong, employees will remember everything. Okay, so number 1, the biggest dispute between foreign companies and Chinese employees is social insurance, in your experience. So before we sort of go into the nature of the disputes, why don't you give a brief introduction, a brief overview of what social insurance is?
Okay. So basically, the social insurance or social security system here in China is comprised of 5 insurances and 1 compulsory housing fund. So they have the pension, the medical insurance, injury insurance, maternity insurance, and the unemployment insurance. And employers are required to ensure that each employee is enrolled in this particular system because it's mandatory and it's a legal requirement that is required by law. Although for the housing fund, it's only limited to Chinese employees. However, for the rest, all employees, foreign, Chinese, they have to ensure that they're all contributing according to the contribution rates. So the social insurance scheme is more of, it's regulated city by city. So each city has its own local regulation. Yes, this is why it's important also for companies, depending on which city that they're incorporating their businesses or their companies, they have to ensure that they're complying with the regulations of that particular city. Yeah.
Yeah, and so I guess that's also where a lot of the challenges might come because like you said, it's different from city to city.
Yes.
I mean, for Kinyu, we have we have employees across China in Tianjin, Ningbo, Hangzhou, Shanghai, Guangzhou, and the rates are different in every single city, and that can be really tricky to navigate. And
Yeah.
just so we're clear, the obligation is on the company to contribute, but also the employee.
Yes, so the obligation is to contribute is both on the employer and the employee. However, the sole obligation to ensure that the employee is enrolled in this particular system is on the employer. So in an instance where they have employees who are not enrolled in the Social Security scheme, the employer will be held liable as opposed to the employee.
Yeah,
Yeah.
and the companies they register the employees.
Yes,
Yeah,
the companies register the employees.
yeah, and so it's not really a choice for the employees. It's they should be enrolled. An employee can't turn around and say, oh, actually I don't want to contribute. Yeah.
They cannot, unfortunately, because it's a legal requirement. It's mandatory, regardless of whether the employee wants it or not. Because I understand, I'm sure, well, moving forward in the conversation, we'll be able to discuss this. But there are companies that sort of enter agreements with employees. But in the long run, that causes a lot of legal, disputes, and because the liability still falls on the employer.
Yeah, exactly. So it's the responsibility of the employer to register, and that it's essentially a tax in a way. It's like in other countries, like I know in the UK you have national insurance, and the contribution, and so the contribution happens from the company side for both the employer and the employee. So the employee actually pays into it on the employee's behalf. Right?
Yes, yes.
Yeah. And so let's talk about the actual nature of the dispute that a foreign company might have with a Chinese employee. Where does the dispute come up?
So mostly the disputes come up in, especially in instances where they agree that they will waive the social insurance. Sometimes what happens is the employee will obviously around they get more information about the system. They will decide that, okay, now I want you to start making these contributions. So the employer will say, well, we already signed an agreement because remember, the employer is trying to minimize their cost as well. They will say, well, we signed an agreement and we might not want to do this, So if the employer refuses based on the fact that they had agreed with the employee and the employee wants the employer to start making the contributions, they move to a legal dispute, the responsibility is going to fall on the employer because this is a mandate. So in an instance where they have an agreement, the employee has consented. If the employee goes back to the employer and say, okay, now you can start making my contributions, they have to be given a certain period of time to actually register the employee. And within that period, the employee must wait. And if maybe say after 30 days or so, they have not been registered, then they can move to a legal dispute to claim the contributions.
So at first, the employee, so in this example, the employer and the employee sign an agreement to say, oh, actually, I don't, you don't need to pay it. But actually, I mean, that agreement wouldn't even be recognized because, under China law, in the labor law, you have to contribute towards the social insurance. So, do you think the company would there be any sort of like backdated challenge around that? So, I guess after a while, the employee says, "No, I want you to contribute." Could they then use that agreement as sort of almost like a proof you haven't contributed for the last year or so?
Yes, it's possible they can do that because if they start, well, in an instance where they refuse to make the contribution, the Social Security Bureau will consider the day in which the employee was actually employed. And then they will have to backdate and pay those insurances based on the date that this employee should have been registered in the Social Security system.
And that's I guess if they're not paying the employee side, they're probably not paying the employer's side either.
Exactly.
And the employer's side tends to be anywhere between 20 to 30%, depending on the city.
Yes.
And then the employee's side could be anywhere between 10 and 15%. Again,
it's relatively
low. Relatively. So you're looking at paying 40, could be like 40% of the salary backdated for however long that you've been employed. Right?
Yes.
So that's like that's a big risk.
It's a big risk actually.
And the social insurance, it's broken into 5 key parts like you highlighted. I mean, we discussed before about how maybe some companies feel like they shouldn't be obligated to pay every single section depending on the nature of the job, right?
Well, mostly the one that is usually in contention is the injury insurance because some companies will state that they're not a high-risk industry. Looking at factories or manufacturing companies, they'll say, well, we're more of a consulting firm or IT. We only deal with pens and paper clips. So what could possibly happen, and they don't feel the need to pay the injury insurance. However, injury is something that you cannot really predict, you know what I mean? It could happen eventually. And when this happens, it will still be the company's cost to cover the employee's cost for incurring that particular injury. So this is why it's generally important that all the aspects of the security system are settled. They're fully paid.
Yeah, I mean, it is a naive argument, I would say, from the employer's side, because I mean, from our perspective, because we employ people on behalf of foreign companies, we take it really seriously because at the end of the day, if they do get injured, again at work, it's an insurance. The risk and the cost is on the employer.
Yes.
And for us, that's why a lot of companies even take out commercial injury insurance as employee liability insurance.
That's another thing.
That's another thing. Well, that's another thing, but. My point is, I just think that it's naive not to pay. I mean, because when you're going to work, on your way to work, could be classed as potentially classed as an injury and things like that. This is a whole different topic that we would probably have to get onto. But just not paying a certain part because they're worried about the injury is a bit sort of short-sighted, I would say.
Yes.
And so I mean, I touched on the risks of not paying the social, about the backdating it. So, a company not paying social insurance. What are these sort of the key risks around it for the company?
Okay. So in an instance where they're reported that they've actually not been paying social security, insurance, they could be fined or they have penalties, maybe say 0.5% per day charged to the total cost that they have not paid. And also legal disputes with employees. as well as damage to their reputation. They could also have their business licenses revoked. And sometimes what happens is that their information will be publicly published. So they have they're publicly named and shamed as a company that does not follow legal requirements, or they've been in violation of the social security system. So that's how serious it is, especially for companies that are just starting out. You're building your business here in China, and then you find yourself in such a situation. You're publicly named and shamed. Your reputation is damaged. It definitely ruins the whole scope of the business.
And I do think that employees take this really seriously. When they're looking at a potential new company to work for, they will search them. It's very easy to search people's legal records online, and if they see that they've been taken to court in a dispute due to social insurance, then it'll be there for everyone to see.
Yes.
And apart from the different rates in in different areas, are there any other sort of regional differences?
Differences. Well, in certain cities, actually, I believe that they have merged the medical insurance with the maternity insurance. So it's more like one thing. If you're paying medical, you're also paying maternity insurance. But I believe that it's cumulative. It's calculated as a sum, as opposed to subtracting the other and saying, no, because, maternity has been subtracted, we're only paying medical. It's paid together, but it's merged as one. Yeah.
Okay. And another sort of aspect, which is, it can be a dispute when it comes up, is when companies under declare the salary of the employee. I mean, actually, we've got an example of this. Is in Hangzhou, we're onboarding a team, and the team were originally employed by the factory of the client's factory, which is a big sort of no in the beginning, but that factory is now they're actually going on an IPO, so they're looking to clear out their methods and their processes, and so now this team is going to onboard onto our China desk. But then when we got the payroll of the team and how that's broken down, we had the salaries on one side, what they actually get, against what their gross salary declared was. And what we realized is their gross salary was the minimum wage, and then there were just loads of different allowances on top of that. And what that means is that the amount that the company was declaring to for social insurance is what is paid. So, for example, if the minimum wage or the wage that they want, it wasn't the minimum, it was the minimum for contributing social insurance. So it was about 3,500 RMB. So they were declaring that the salary is only 3,500 RMB, and therefore they would only contribute 26% on 3,500, whereas some of their salaries were 13,000 or 14,000 RMB. So instead of contributing 26% of their actual salary, they were only contributing 26% of 3,500, which is cost effective for the company. But then all these allowances were actually part of their salary package, so they're actually not declaring it. So how for that instance, I guess one consequence is that the employee knows this, so they could come back and claim that they've not, that they deserve more contribution into their social insurance, right?
Definitely. It could lead to a legal dispute, actually, because it's a serious violation. And also they could either pay a fine, because now in such a situation, they have to carry out an investigation. If you're saying that they've been paying them in more allowances, their Social Security Bureau would definitely have to consider all the in-house aspects of the payrolls, payments, and when did these employees start working? How much outstanding contribution is, haven't they been paying that they will be required to now pay?
Yeah, so it could be, I think that some of them have been working there years. So they could be, now that they're onboarding onto our China desk, that that previous history is with a previous employer, but it's something that we're having to tell the client
Yeah.
that their costs are going to go up.
Yes, definitely.
Because they need to contribute to this in a compliant way.
Yes.
So yeah, I think these are the main challenges, main disputes that you've experienced with
Yes, with foreign companies regarding social security, actually.
Yeah.
It's very big, and also the issue of the misunderstanding, misconception of social security. I'll give an example of the confusion between social insurance and commercial insurance.
Yeah.
Some companies think that if they pay the commercial insurance, then they can offset the social insurance. They don't need to pay the social insurance because now they're paying commercial insurance. Or maybe they will not pay the medical insurance because they're paying for the private health, yes, for their employees. But that's not the case. For the social security system here in China, you have to pay all the 5 aspects of it.
Yeah, absolutely. I mean, they should probably instead of calling it insurance, they should like in some countries they say it's social security, right? I mean, at the end of the day, it all goes into a big pot that that money that the government used to run hospitals and pay the bills, etc.
Exactly.
So it's really serious. So yeah, I think let's move on to the next topic.
Okay.
So the second largest area of dispute between foreign employers and employees here on the ground is the non-compete clause. Failure to pay the compensation on it for honouring the agreement. Karen, do you want to just give an overview of non-compete clauses in general and what is the nature of the dispute?
Okay. So basically, the non-compete clause is usually an agreement between an employer and an employee that states that an employee cannot work for competing companies. Yes, either be it consulting or just a general part-time, they cannot work for competing companies or open a competing business, meaning they cannot incorporate a business that is the same as the company that they were working in. And this usually happens, or the non-compete clause mainly becomes enforceable after the employee's contract has been terminated. So the cap is that this agreement can only be enforceable within 2 years. So after 2 years of after termination of the contract, within 2 years only is when they will be, required to comply with this agreement. However, the catch is that this agreement only applies to senior managers, senior technicians, or employees who have access to the company's trade secrets or just the general technicalities of the company. And also regarding the scope as well, the issues of the scope, the geographical scope, it is limited to the place of operating, where the business is operating, and where the actual competition is, because it's a bit unreasonable for the non-compete clause to state that this is a global, it's a global limitation, that you cannot work in other companies in different countries because they're competing. It will be unfair to the employee as well. And one thing that is important to note, that where the legal disputes actually arise, is the compensation, because the employer is supposed to compensate the employee for honoring this non-compete clause. So the nature of the legal disputes is always based on the fact that they have not been paying the employee. So sometimes what happens is the employee might get a job in an actual, competitor, and they'll say, well, I'm not obliged to honor this agreement because you're not paying my compensation. Yeah.
And so in terms of the payment, is the compensation, is that paid when they leave, or is that paid sort of up front when they join?
When they leave.
Yeah.
Yes. In most instances, after the termination of the contract, they're paid based on the average salary prior to the termination. So once the contract is termination, they now start paying compensation monthly.
Yeah, and the percentage of that, is it?
Well, the standard economic compensation is about 30%. Yes, it doesn't go up. It could be a bit lower, but it's 30% usually. Even for legal disputes, the court will grant you 30%.
Yeah, so 30%, if it is the sort of highest level that companies really should consider paying.
Mm-hmm.
No, that's really interesting. So an overview is they sign the agreement at the beginning
Yes.
of their employment relationship, along with probably signing the contract.
Mm-hmm.
And then they will, when the employment relationship ends, this sort of agreement sort of comes into effect. They won't be able to work for a competing company within 2 years, and they'll get paid 30% or up to 30% of their average salary from the previous 12 months.
Yes.
For how long?
Well, for the 2 years, actually.
For the whole 2
Yes,
years.
for the whole 2 years.
So, okay, yeah. And, you talked about the scope and enforceability and, for example, globally, that would be really difficult to enforce. And how about, what are the sort of key ways, how do you advise your sort of the key ways to make the scope more reasonable so that it's actually enforceable?
So that it's actually enforceable. Mainly for our clients, we advise them to at least, prepare a list of companies that they consider to be actual competitors. This also makes it easier, for the employee to also be able to have an idea and say, if I work here, this is a competitor. And for clarity purposes, it's important that it's not a legal requirement. It's not required in the Chinese labor contract law or anything, but it's just the most reasonable thing to do, to at least come up with a list that shows the employee that, okay, these are the actual competitors and I cannot work here.
Yeah. That does make a lot of sense. I can imagine challenging, in some industries in China, like maybe the electric vehicle industry.
Yes.
You could have a list of car companies, electric vehicle firms at the beginning of the relationship, but maybe at the end, the industry is so fast growing that the list
Yes.
might be completely different. There could be several new players.
Yeah.
Some of those companies might not exist anymore. But I mean, could you add players into that? I guess in that particular example, it's quite obvious because the list, not only does it help you to specifically say don't work for these companies, but it also is almost like a trend. So for example, if you've got these 10 companies, like a EV electric vehicle firms, and then another electric vehicle firm, comes up in the industry, then it's clearly sort of that list will help to provide a bit of a precedent. Right?
But you know what, Ben, in such an instance also, we always recommend to our clients to be a bit more specific. Okay, you may not have the list, but you can be specific with the industry at least, because as you mentioned, China is a very competitive market. There are always companies coming, and they could be competitors as well. So to curb that kind of ambiguous, all that kind of issues, it's important to have a specific, or in the agreement to be specific about which industry, what aspect of the industries, are employees not allowed to work in the competitor companies.
Yeah. And I guess that would also, it would depend on the position that they hold, right?
Yes, yes.
If it's a technical position, an engineering position, or if it's a senior management position.
That is also very important when it comes to legal disputes, actually. Not all employees are obliged to sign their non-compete.
Yeah.
They have to prove that the employee is holding these kinds of positions.
And is this normally a clause within a contract, or is it, do you tend to have a whole separate agreement for non-compete?
Well, according to the labor contract law, the employment agreement usually has the clause, so even as we are drafting here at the firm, the non-compete clause is mainly enclosed in the actual labor contract. But sometimes for more clarity, if you wanted to, to have more information and all that, it's possible to have an agreement as opposed to a clause, but mostly in practice, it's just incorporated in the actual employment agreement, in the labor contract.
Okay. And do you think, the non-compete clause in China, how do you think it compares with other countries, and do you think it's not fair, but do you think it's it makes sense, or have you got any other comparisons?
Well, I would say it's a bit more strict actually, because in other countries, compensation is not a must. And I'll give an example of maybe the US. It was actually banned in certain states in order to just open room for competitors, But I think it's more strict here in China specifically as opposed to other countries. Yeah, especially the aspect of the compensation, which is also very vital here in China.
I guess it's a well-structured non-compete agreement can here, like you said, because it's banned in other countries. You can protect the company, provided that it's structured well, and also that the employer actually pays it, right?
Yes, yes.
And so going back to the reason for dispute is because is it a company signs the agreement, but then just doesn't want to pay the compensation?
Yes, actually, that's what happens. They sign the agreement and they don't want to pay the compensation. And even as I mentioned earlier, so the employee will feel, okay, so I can work for a competitor because you're not paying me the compensation. Yeah.
So the dispute sort of arises when the company finds out that the employee is working for a competitor, but then you didn't actually pay the compensation.
Yes, you didn't actually pay the compensation,
Yeah,
so
that's
you have no legal basis.
yeah. No, that's really interesting. Okay, great. Well, that's non-compete. And by the way, if you're just joining us now, remember to like and subscribe and learn more about how to manage your employees on the ground. So the third biggest dispute or area of dispute is termination of the employment. And within that, we're talking about the reason for termination, right?
Yeah.
So, I mean, obviously, terminating contract is it's a huge topic.
Yes.
But let's talk about what is the sort of nature of the dispute then when it comes to termination, do you find?
When it comes to termination, the common, disputes that arise are wrongful termination. Well, maybe an employer will dismiss an employee based on the fact that they're performing poorly, right? But the employee will dispute and say, "What do you mean I haven't been performing well?" And now the employer will be required to provide more evidence to prove that. So basically, because the labor contract law provides for the legal requirements that need to be met before you can actually terminate an employee. So it amounts to wrongful dismissal, wrongful termination, if it does not meet the requirements that are laid down in the labor contract law. Yeah.
Yeah, I guess performance is quite subjective, right? If they do something majorly wrong, then the company, if they have a good employee handbook, for example, they put the company into disrepute or some sort of incompetence level that is is quite serious, then it's quite straightforward, I guess. But a lot of the time, it's more subjective and sort of ongoing, performance not really meeting the expectations of the company. But I guess, like you say, you can't just dismiss them like that.
No.
Even if they're right, they're not performing. But because it's subjective, it has to be documented,
Yes.
communicated with the employee as well, isn't that? And so I guess that's where the employee they just disagree because they've had no indication of whether or not they're performing properly, or whether or not they or that that they've been given targets, etc.
Yes. Yes. Yeah.
And so around this, I mean, like, how do you advise your clients when it comes to performance? Do they come to you first saying, "I want to fire this person," or is it more they come to you when the employee has actually disputed it?
It actually happens in both ways. Sometimes, especially the ones who are on a retainer, they'll just come to you and say, well, I want to dismiss this employee. How do I go about it? And for poor performance, the best way actually we advise our clients is there has to be proof. You have to document it as you mentioned. Maybe say via email. Maybe you sent warnings via email to this employee. You've been calling them out about their poor performance. Or also there has to be maybe you switch their role to see if, maybe it's just the role that they're in. Try to put them in another role. Because it's important to note that for poor performance, you have to prove that this employee is actually performing poorly. So it goes down to you have to do the documentation, record filing, try to switch their role in order for you to, try and assess them in a different position. Because all these things will be required of you in court in an instance where a legal dispute actually arises.
And have you had an example where the termination has been reversed, or it's mainly, I guess, more compensation is provided? Is it, if they can't find, if the dispute arises and they can't find clear indication that they performed badly, what's the consequence of that?
So if an employer cannot prove that this employee has actually been performing poorly, they have to reinstate their employment, meaning that they have to employ them again because, they have no proof, So
that will be an awkward Monday morning
yes,
meeting.
exactly. So the consequence really is reinstatement to re-employ this employee back in the system.
And I guess that probably also depends on sort of like the size of the company. You can imagine if it's a very large company, reinstatement of the employment probably makes more sense. I mean, maybe the line manager not too happy about it, or etc. But in the end of the day, it's a large company. But a small company, if you've only got a small team in China, which is mainly the kind of companies that we're working with, we're hiring 4 or 5 people, and then there's one person who's been sacked, but they're still here. That must be that's a big challenge for them. And
it is a big challenge.
I can imagine that they'd probably negotiate some sort of severance, wouldn't they?
Yes, in the end, they'll probably just negotiate some severance, pay this employee severance pay so that they can just go.
But just to be clear, trying to terminate the contract for poor performance without the adequate proof and evidence or any efforts to restructure or communicate this with the employee is that actually a breach of labor law? I guess it's a termination on the not the right grounds, right?
Well, in most instances, it will be phrased in a way that, well, this employee is not meeting the standards of the company. They're not, because each company has their own performance standards. So how they will put it is, they're not meeting the standards of this company or the conditions. And that is also in the labor contract law. But the catch is you have to prove regardless.
Okay, that makes sense. And we'll come on to it in a minute, but even though they haven't been performing and you do terminate contract, you still have to pay the severance.
If you do terminate the contract, yes, you have to pay the severance. Yes.
Okay. So that is definitely an area that is tricky, that requires a lot of support on the ground.
Yes.
Companies need to be well informed. They need to have a plan for their termination, and instead of just jumping into it and in the heat of the moment. Okay. Well, that's termination. Okay, so topic number 4 is linked to termination. Is actually severance pay. So when the employee leaves for various reasons, the dispute around severance pay, failure to pay it, or maybe or maybe over, an argument over the amount that should be paid.
Yeah.
So, foreign companies, they don't like, you said that, they're not happy with paying the severance. Of course, a lot of companies, they would feel frustrated about paying, such fees. But even though it's quite clear in the labor law, why is it such a common dispute? Why do they not want to pay the severance?
For foreign companies, I believe it's a cost issue. They're trying to minimize the cost because, severance pay, depending on the calculation, it's 1 month of each year,
Yeah.
So to many companies, they'll be like, that's too much. And if you have employees who have worked for 5 years, 6 years, that's a lot of money to pay. So
Yeah.
mainly the reason actually they don't want to pay is because it's a cost issue, Yeah.
So they try to avoid paying it.
They try to avoid paying it, actually.
And from their point of view, how do they try and avoid paying it, even though it's sort of,
Yeah. From their point of view is they will try to agree with the employee also, in a sense that maybe they'll ask the employee to waive it or they will ask to pay lower. It only becomes an issue you reach as far as the calculation when it becomes a legal dispute, but internally maybe they will say we can pay you this amount as opposed to the legal amount that is required to be paid.
And an employee, I guess, why would they accept anything less than the amount?
It's knowledge.
Yeah.
Sometimes even if
it's
the
knowledge,
employees,
yeah.
yes, even the employees don't know, they don't know that there's this thing that's called severance pay or compensation. They're not sure. They would know, but maybe they don't know about the actual amount, that is accorded to them.
That's true. And, this severance pay is across the board. It's, senior managers, all the way down to factory operators. So it's, like you said, there will be, there could be a lot of people who they don't really know their rights. They don't really know the labor law.
Yeah.
But I mean, in my sort of experience, I feel like the employees that we employ are very knowledgeable about all of these areas that we talked about, and they will be knowledgeable about severance pay. So I can imagine that a lot of companies would challenge it, but yeah, that does make sense. So severance pay, I guess a lot of companies, they would maybe try and consider areas or aspects where it's not mandatory. I mean, it's mandatory in most cases, but are there any? There are some examples where it's not mandatory to pay severance.
Yes, maybe summary dismissal, where the employee causes like a serious violation of the company's regulations and laws, or where the employee just resigns with no justifiable reason. They just resign on their own. They decide that they don't want to work with the company anymore. There's usually no requirement to pay severance pay in those two instances. Yeah.
And I think one of the areas where companies also get caught out is at the end of fixed-term contracts. I don't really know what's the comparison with other countries, but I know that in China, if you have a fixed-term contract, say 2 years, then if you decide to not renew, so it's not really a termination of a contract, but it's a non-renewal of at the end of a fixed term, you still have to pay severance.
Yes, actually.
Yeah, I think that's an area that we always advise our clients. If they sign a fixed term contract, which is good, but you still have to pay. It's easier to terminate a contract at the end of that because it just expires. But if you don't want to renew, you have to pay the severance.
Yes.
And the issue around the severance pay, do you find that it's companies want to pay less, but are there disputes where Chinese employees feel they deserve more above and beyond their salary?
Well, for company, it's very common. They definitely want to pay less, but in some instances, yes, even the employees would want more. But at the end of the day, what keeps it together is there's a legal standard already, So even when there's a legal dispute, they will consider the years this employee has worked, and according to the standard calculation, that is the amount that they will be entitled to, which is their legal amount.
So you mentioned earlier just about, the amount of severance pay. Do you just want to clarify how it's calculated?
Okay, so the calculation for severance pay is 1 month for each year,
Yeah.
and 0.5, which is half salary for less than 6 months.
Okay.
Yes, so if an employee has worked maybe for less than 6 months, they'll be entitled to half month salary. But if they've worked for 1 year, that's 1 year salary. 2 years, that's 2 months salary.
Yeah.
You get it, right?
Yeah,
I know
yeah.
there's a bit of a confusion there, actually.
So within the first 6 months, it's half a month's salary.
Yes.
So 6 months to a year. So if let's say they've worked for 8 months, they would be entitled to 1 month.
In most instances, they would be entitled to 1 month. That's a good question, actually. But mostly it's, within 6 months, you get half.
Yeah.
And maybe it could be like 0.7 if but the calculation is like that.
Yeah. 1 month, you said like for the number of years, the number of months salary, but it's not just their sort of gross salary, it's the average of the previous 12 months, isn't it?
Yes, it's the average, because I'm over the understanding that in cities like Shanghai, their pay is really high. So in such instances, even the severance pay will be high if you go for the gross salary.
Yeah.
So the focus is the average monthly salary. So it's 1 month salary for the average salary.
Yeah, the average of that employee. Yeah.
Yes.
So,
yes.
So for example, if you think they have a low sort of base salary, but they get a really high bonus, and you think, oh, I just need to pay one month of their base salary, that's not entirely true. They would factor in everything that they've earned in the last 12 months.
Yes.
Including their bonus, including maybe other bits, and then divide it by 12. And then that is that's the monthly salary.
Yes, but it's 1 month salary.
Yes. Yeah.
Yes, for each year. From our experience, mostly our clients, they come, it's not usually like they've only worked for a short period of time.
Yeah.
Most of the times when they're, legal disputes, they're going to labor arbitration, it's they've worked for more than 5 years.
Yeah.
And now this company does not want to pay their severance pay.
Yeah. And at that point, there's the dispute. The employee disputes it. What happens next? I mean, if they don't settle this, what would happen next?
Well, if the employee wants to claim for the severance pay, right, they can file for a labor dispute, labor arbitration. And if they're not happy about the award, then they can move to trial, which is litigation. And in that instance, they will also consider the legal requirements that are provided for according to the Chinese law. So in many instances, the overriding point is that the payment has to be in accordance with the law.
Yeah. And speaking of that, are there any sort of regional differences or nuances, do you think?
Well, for the payment, the standard is consistent. The calculation that I just explained is the same. But in certain regions, maybe in Beijing or Shanghai, the payment might be slightly higher because they have maybe a higher minimum, average pay, which is they have higher salaries or higher base.
Yes.
So the calculation and the payment might be a little higher.
Yeah, that's right, because isn't it there is a cap on severance pay, isn't there?
Yes, there is a cap on severance.
Yeah, is it 12 months of the average 12 months of the average salary in that city?
Yes, in the particular city, because they will also consider the payment, the salaries as well.
Yeah.
In Beijing, Shanghai, they're really high. This is why they put the cap.
Yes.
Because imagine someone is getting paid maybe 60,000 a month, and
they've worked there for 10 years.
Yes, and they've worked there for 10 years. So
there is a cap on that. But I guess and that will there will be those sort of larger cases, but
Yes.
a lot of the time it will be lower.
Mm-hmm.
Unless, I mean, if someone's worked for 20 years, then and then there's a termination like that, then there's definitely going to be some sort of settlement
Yes.
required there.
Yeah. Yeah.
Right. Okay. That's severance pay. Just to summarize that, I do, to avoid the dispute in the first place, I think companies need to consistently budget for these types of scenarios. Relationships, they don't last forever. So, factoring in, to what, how much that a company could be liable, it's definitely worth to prepare that in advance and be aware of that, just in case the termination does end for whatever reason and you need to pay that severance.
Yeah. Yeah.
Okay, so the final topic for today, number 5, another major dispute is around overtime and leave. So, Karen, what are the most common disputes between companies and employees when it comes to leave?
When it comes to leave, one of the main disputes stirs around annual leave and the entitlements that are attached to annual leave. So, as you know, that annual leave is vital. If the employee does not take it, they have to be compensated fairly, actually. So, what usually happens is we have an employee who does not take the annual leave, and they want compensation. So the issue usually stirs around the actual compensation for the annual leave, and maybe the employee would decide to claim after their termination. They say, well, I didn't take my annual leave for these particular days, so I want my compensation. And employers are required to pay that compensation. And usually it's about 300%. It's
300%.
high. Yes, it's very high, actually.
Yeah.
So
That is one that definitely requires a lot of planning. I mean, we have this challenge with, again, like Chinese people, they work so hard.
yes.
And a lot of the time they don't really allocate, time off. And, even though sometimes you say that, the amount of annual leave that someone is entitled to, can be less than in many other foreign countries. But there could still be some left over. I mean, from a sort of supply chain manufacturing perspective, one really interesting example from our point is QC engineers. They're working, they're doing inspections, and they have really busy periods, and before they know it, they haven't really taken this time off, and so it's really important for the company to plan. If they feel like they're not taking that they're not going to take the time off on their own accord, they're just going to keep crashing through the inspections. Company needs to plan for time for them to say, you need to take this off, right? Because otherwise, the employee, I think most of the time they're not trying to sort of game the system, they're just working hard. But then if they will feel unfair if it comes to their following year and their annual leave just gets docked. They'll probably make a claim, won't they?
Yes.
And that's also it's also linked to overtime, right?
It is.
The adequate sort of compensation for doing overtime.
Yes.
Can you tell me a bit more about sort of where the dispute arises with that?
Overtime, also the dispute arises with the compensation, right? Because for overtime pay, there are 3 instances where the employee can either rest, the employee can either rest, right? Or they have to work maybe on a weekend. That is considered overtime. And the percentage also for paying that compensation is high. And it's even higher for public holidays. If the employees have to work on holidays, the compensation is higher. And sometimes the dispute arises when maybe the employer will say, but we didn't approve this overtime. How come you took overtime and we were not aware of it? There's a case I would like to give an example of. There's an employee who was claiming overtime pay, right? But the employers were stating that we were not aware of, we did not approve this overtime. But this employee stated that they had informed their internal administrative manager, who in turn started processing this overtime. So the court stated that for the administrative manager to start processing, it means that they had agreed and they had, they were aware of this overtime. Why would you process something that you are not agreeing to? And in the end, that employee actually got the compensation. But it's usually important that the employee obtains pre-approval if they want to avoid, later disputes.
Yeah, and I guess so. That's a miscommunication within a company structure, because a
Yes.
lot of the overtime application will be on Wecom or some sort of software,
Yes.
and
Online.
and the person looking at the software on a database, it could be the HR manager, it could be some sort of admin person, not really familiar with the requirements of that person's work, and so the line manager is the one who knows whether or not they actually need to do overtime or not.
Yes.
And so that person, instead of getting approval from the line manager, they've just gone straight onto the system, and then the system is like, oh, okay, we'll just start processing it without the line manager's approval. Or like you said, maybe the line manager has sort of seen it, but they haven't really acknowledged it, or
Yes.
something like that,
Yeah.
which is a challenge. So, I mean, how should companies manage this? How should they manage this in a more structural manner?
I think in a more structural manner, I would suggest a systematic, automated, maybe applications where, employees can just apply directly and you have someone looking over it. And there has to be clear application procedures, So you tell the employees, it should be clearly provided that if you apply for overtime, you have to wait for approval. So if the employer makes the application, if there's a procedure that is set, they will know that I only work overtime if my manager has approved this overtime. So it's a matter of setting up, applications or clear policies as well surrounding the overtime application, the procedure of the overtime application itself.
Yeah, I mean that's a really sort of important point. I mean, just for companies, especially if you've got teams on the ground, there is HR structures that you can create, which is important, but also it's around the management and the planning of their work.
Yeah.
So from a QC engineer's perspective, you need to understand that whoever's approving it, if it's from the HR point of view, needs to sort of understand what their plan is that week, and then so that they can see when things are happening, when they need to go to do inspections. It could be on the weekend. The shipment could be going out on the Monday, etc. All of this needs to be planned. It needs to be structured, and it's not just a case of having people on the ground. You have to have the management on the ground as well.
Yes.
Yeah, and like you say, very clear policies around that overtime. Because I mean, like I said at the beginning, people a lot of the time it's actually people aren't doing it to game the system. They're not doing it to in a sort of nefarious way. They're just working hard. They know the shipment needs to go out on the Monday. They know they need to go, but maybe they just don't know how to apply, or they don't know what the rules are, or maybe the company has got other priorities and actually they don't need to go. You don't need to go, so just don't go. Sometimes that's not very clear.
Exactly. I think in most instances, actually, that's where the issue arises with the overtime. I mean, this is a high manufacturing country, right? And certain things just happen there and then, and this employee will be required to work overtime.
Yeah, and some things can wait until the next day.
Yes.
And a lot of the time it's also working late at night. I mean, you've got overtime, which is, on the weekends, but then how does it work with working late as well.
So this is why policies in the company, I believe, is there's always there has to be more like a room to say in an instance where you are not able to make the application, but you worked overtime, maybe you can provide documentation as to why you were working overtime for this, and then that should be subject to approval by your manager or your HR.
Yeah. It's really important that companies realize and the employees realize. I mean, because you do see it, especially with a lot of work going on WeChat, on their personal WeChat, and then people leaving work, and they're still the factories are still replying to you about various things, and
Yes.
you're there in the office. Well, actually, it can wait until the morning, but people just they might jump on a call and try at that very point on that sort of instant part, and actually it requires a bit more structure and a bit more discipline
Yes.
from the management, but also the employees. The employees need to know and they need to be informed that if something can wait until the morning, then it should happen in the morning.
Yes.
If something cannot wait, then the management should tell them this needs to be done tonight. You can apply for overtime, or apply for overtime, and we will approve it. And you'll get the compensatory leave or extra pay compensation.
Yes.
Yeah. And so I think we've covered sort of that's where companies really get caught off guard, isn't it? Because it's very voluntary. People are more than willing to just put in the extra mile because they work hard. But managers should respect that, and it's a tricky one that can come to bite you in the end.
In the end, yes, because you have an employee who will file for labor arbitration and they'll be saying, I was not paid for my overtime.
Yeah.
And I didn't get the compensatory leave that was entitled to me.
Yeah.
So
Yeah. And I mean, what about the compensatory leave and compensation? Do you have any sort of guidance on when compensatory leave makes sense and when just having to pay compensation?
Especially for overtime that happens on weekends where an employee is required to work on a weekend, then they can be given either a compensation or a compensatory leave to say, okay, you worked on a weekend, you can have this day, rest day during the week. You can take any day during the week to rest. That is the compensatory leave, as opposed to actually paying the compensation.
Yeah. And is there is there a time frame to take that? Does it have to be within the next week or?
Usually not really. Maybe within the same month, you could.
The same general period.
Yes, in the same general period.
Yeah. And we just the best way to track and manage this. A lot of software helps.
Yes.
But then also, core management. Someone who's across the needs of the business and the administrative side.
Yeah, especially the HR. I mean, the HR have to have their eyes out there.
Exactly. But that's where just from Kinyu, what we do as we're a supply chain focused employer of record. So we do all of the HR for these companies, and that's why it's so important to have that kind of management and oversight over the operation. Is because if it's just an HR, if it's just a software, or if it's just a faceless HR sort of employer of record model, they won't understand the needs of the business. And the manager overseas, if their line manager is overseas, they don't understand the local policies or what's required. Then there can be a gap.
A big gap.
Yeah, so it does require a bit more management on the ground.
Yes, definitely.
Yeah. And I mean, what about other sort of types of leave? I mean, do you find any sort of disputes, within sort of like sick leave or maternity leave? Or?
Yes, definitely for the sick leave, because even the sick leave is subject to approval by your boss maybe. And if you make that application and your boss does not approve it, they cut your salary regardless. So yes. So when you take a leave, maybe sick leave, they pay you maybe they 60%,
Yeah.
and then the rest, is keeping. But sick leave also is very, integral because sometimes it's difficult for employees to prove this, and even when you say, oh, they didn't pay me for my sick leave, but did they approve it? That's the thing. So it's also subject to approval, which
Yeah.
leads to.
I think sick leave, in my experience, sick leave seems to be I mean, it depends. You have the medical treatment period, and a long sick leave is quite employee friendly, but part of it I find is actually quite employer friendly. The amount that is required to pay is a lot lower than I would have thought for sick leave. And like you said, if you don't provide the proof,
If you don't provide the proof.
then it's like, well, we don't need to approve it. And so maybe you just take, unpaid leave or take your annual leave, and if you don't have proof. And so I think sick leave, I can imagine there are some disputes. So there are some elements where the employee might feel unfair, but there are some areas where I think it's quite employer friendly actually.
Yes, definitely.
But but then that's the nature. I mean, overall, in the labour relationship is very employee friendly. So and I guess we touched on public holidays. Working on those days, it can be up to 300% if they work on the core days. That's it's definitely one to try and avoid if you can.
That's well, it's definitely something that needs to be avoided actually, because the compensation, I don't think it's something that some companies will be ready to pay.
Yeah. Okay, I think we've covered everything on leave, haven't we? So everyone, that is the top 5 disputes. So if we can have a bit of a roundup, so paying social insurance, that's the number 1 dispute.
Very important.
The non-compete clause, it's one that not every individual will be subject to, and not every company will have this challenge. But it is a big topic, especially when it comes to China, and from a manufacturing and technical point of view, it would come up quite a lot. Number 3, termination and the grounds for termination, always very tricky, very around performance related. Number 4, severance pay, the amount, whether or not to pay it, how much. And of course, number 5, overtime, leave, challenges around leave, different types of leave, holidays. Some quick takeaways I've thought about with these is number 1. So foreign companies, they face disputes, challenges. They face different challenges, different disputes compared to local companies here in China. So depending on what you know about China, it's important to understand that not every company will be treated in the same way or have the same types of challenges. Another key takeaway, just because the employee voluntarily does overtime does not mean that they waive their rights on it. If they are working overtime and they don't say anything, then it doesn't mean that you don't have to compensate them for that. So it's really important that as a foreign manager managing Chinese employees, that you stay on top of that. Another one, I think most disputes come at the end of a labour relationship, but there are some notable examples, like, for example, the non-compete clause. That could happen at the beginning.
Well, Well, if the employee disagrees with the terms, yes, it could happen at the beginning, but in most instances, it's at the termination of the agreement.
Yeah, and the social insurance, a lot of that. Again, these are all sort of issues that rise up to the surface at the end. The dispute comes at the end, but the transgression happens earlier. So that's the challenge, really. I guess some individuals might dispute the social insurance at the beginning, but but it's usually sort of latterly. And as always, you know, there are nuances to all of these different laws, different, you know, examples. The enforcement of them different in different cities. So it's always really important to get very specific advice on your particular situation. So thank you very much for watching, and thank you, Karen, for for having us here and
My
for your
pleasure.
contribution.
Thank you for having me, Ben. This has been great.
Yeah, brilliant. So if you want to learn more about this and follow us, then make sure you like and subscribe, and look forward to seeing you in some more episodes where we explore all different areas of management on the ground.